Just two matters very briefly. First of all, I touched up a letter from the Department of Transport on the 16th of November 2021.
Right.
This goes to the point we were discussing before lunch about the apparent extension of time for the second consultation round. And I apologise that I was wrong. I thought we had an individual extension, but I misunderstood something. And what had happened was there was a general extension given to the 3rd of December because there had been errors in the published version of the draft assessment report. The second round consultation responses, including the IBA report, only then get published in January. So even with the extension of time, no one will be able to see what the responses were on this. But I just wanted to get the chronology correct on that.
That's helpful, thank you.
Then, my Lord, I think the final point my Lord left open was paragraph 265 of the decision, reference to redetermination correspondence. I've already covered the fact that the Secretary of State, in our view, rightly thought that Rule 19 applied to redetermination. What the Secretary of State is dealing with here, and as having gone through the correspondence before lunch, I hope makes that good, is dealing with letters which went in, representations which went in outside the consultation periods. He's not in 265 dealing with responses within the consultation periods, in particular the IBA report. So in 265 he doesn't address his mind under Rule 19 whether there should be a further consultation under that rule to deal with the IBA report.
Okay.
Well, let's anything else.
Very helpful. Thank you very much indeed, Ms. Howard. Yes, Mr. Westminster-Smith.
My Lords, I propose to address you just ground by ground in turn. So I'll start immediately with ground 1A, that the Minister unfairly took into account the Asimov report when the underlying review transcripts were not provided. In terms of background to ground 1A, it's important to understand the structure of the Asimov report. There are extracts in the bundle, but by no means all of it. It was a lengthy 4-volume report. Can I just show the court how the EXA described the Asimov report? That's in the supplementary bundle, page 695 and 695 and 696, which I believe is page 157. And you should find yourself in examining authorities report under section 5 need. And at the foot of page 695 is paragraph 522. The applicant's detailed justification of the need for the proposed development relies heavily on the Asimov report. And then it says the report aims to answer 3 questions of its own setting, and those questions are set out at the top of 696. And then the next paragraph, 523, describes the 4 volumes. And volume 1 was dealing with demand in the South East. Volume 2 was the qualitative study of potential demand. It's that volume the interviews relate to. And then the information in volume 2 leads on to a forecast, which is quantitative in nature, in volume 3. Volume 4 deals with economic and social impact of the airport operations. So it's volume 2 that's the focus of this ground. And volume 2 of the Asimov report is picked up in the bundle on page 6. Well, the start of it is on page 582. But the relevant page is on page 602, which is page 64 of the supplementary bundle. And I won't dwell on this because your lordships have been taken to this page before.
Just pause a minute, would you? Sorry.
Page 602.
Can you then give it? Yes.
Page 602 is interview identification. And that process is described at 322 and at 323. The table overleaf of page 604, the list of interviewees, 24 of them, is pointed forward to. But at 3.3, there's a heading semi-structured interview schedule design. And it says a semi-structured approach was used to collect rich data from the interviewees whilst keeping the interviews on track. And then figure 7 sets out the list of interview questions allied to questions that are designed to pursue the bullets that are set out at 3.23. So there was a structure to it. And then can I just highlight page 605, paragraph 3.42. That's important. It's the paragraph that says the transcripts have not been made available due to commercial sensitivity, but that the responses have been incorporated into the findings presented in section 4. So you have to look forward to section 4, which is entitled Findings and begins on page 606. And I'm not going to trawl through that section, but it's 30 pages of text, and it's split into 5 headings: findings by category of interview questions. And I know a friend took you to, that's 4.1 beginning on this page. And then freight focus findings 4.2, channel crossing market share 4.3, 4.4 is passenger focus findings, and 4.5 other potential revenue streams. And the only point to make, to emphasise to the court, is that all of those sections are based on interview responses, not just section 1, which is the findings by category of interview questions. And I can make that, or I can illustrate that at least, by asking the court to turn up page 611. That's page 73. And this is where the next section begins. 4.2, freight focus findings. 4.21, many interviewees talked about. And then the next paragraph, the main issues for interviewees were. So all of this 30 pages is based on the interview process. It's primary market research. And what it does, as the judge identifies in paragraph 8 of the judgment, is that it feeds through into volume 3, and in that volume, the report converts, Asimov converts that analysis into a quantitative analysis. And you can see that in a snapshot in the EXA's report on page 717 of the bundle. So page 717 is within the EXA report. And at 5.6.49, table 1 is replicated, and that is table 1 of volume 3 of the Asimov report. And you can see that it predicts total tonnage passenger numbers through a 20-year period. whilst the transcripts weren't provided, the list of interviewees was, and the substance of the responses given by the interviewees had been incorporated into the findings of the report over those 30 pages of section 4. My learned friend took you to how the EXA dealt with the Azimuth report. That was on pages 718 and 719 of the bundle. I don't need to take the court through those paragraphs, but can I just emphasise one point? And that is that at paragraph 5.6, 57, which is over the page on page 719, what the EXA does is, in light of the fact that transcripts have not been made available, limits the weight, third line from the bottom, that can be given to the Azimuth report. So the approach of the EXA was to go to weight. They thought it was a question of weight, not relevance.
Could I just pause to mention something? I understand the sound isn't terribly good on the live stream recording, and it may have something to do with the positioning of counsel and the positioning of the microphones. It shouldn't be a general issue, but I wonder, could I trouble you, Mr. Westminster, to make some room and to move along so that you're somewhat under the microphone, because that might improve the quality for people who are trying to follow the argument remotely. Take your time and don't spill the water. Thank you. Thank you very much. Could you just give me the last reference?
Yes, of course. So I was in the examining authorities report, page 719 of the bundle, and it was paragraph 5.6.
Just a moment.
0.57. 719.
The paragraph was
5.6.57.
yes, we've been there. Been there before.
I then just very briefly go to the decision letter. So in the core bundle, and the relevant part starts on page 422. Paragraphs 82 and 83 are summarising the approach taken by the examining authority to the Azimuth report. And you can see just above the quotation in paragraph 82, the examining authority considered that because the applicant withheld the interviews and other sensitive data, this limits the weight. But the Secretary of State's conclusions, which are to be focused on, are at 424 in the bundle, and paragraphs 89 to 94. And at 89, effectively what the Secretary of State is saying is that he prefers the qualitative approach in the Azimuth report. And then paragraph 90 he explains why he disagrees with the approach taken on weight by the examining authority. And I'd ask the court to read that paragraph with care, because it's a detailed explanation that recognises there's a difference, explains its reasons.
Yeah, I wanted to ask you about that. One of the reasons given by the Secretary of State for disagreeing with the XA's conclusion that the absence of the confidential information reduces the weight is that the withholding of commercially and other sensitive information was justified. I can't see, that looks like a non sequitur to me. Suppose that it is justified to withhold the commercially sensitive information. What does that have to do with the weight to be given to the conclusions?
The Secretary of State, I think, there is recognising that in the general planning sphere, where instances of commercially sensitive data comes up, then there can be justification.
That's easy to understand, but
yes.
the withholding of the information might or might not affect the weight.
Yes, I think,
assuming it to be justified, which often it will be.
yes.
It depends on what you're left with.
Exactly, and what you're left with is effectively every other sentence in that paragraph. So he notes it's justified, but the reasoning extends much beyond that in relation to weight. So overall, on the decision letter, firstly, the Minister was satisfied that he had enough information to come to a conclusion on need. And that is, well, it's important to note in doing so, he didn't have the transcripts himself. Secondly, he did find that the withholding of commercially sensitive information was justified. Thirdly, he noted and understood the EXA reduced the weight to be applied to the azimuth report because the material was not provided. Fourthly, the Minister was entitled to come to his own view on that. He did. Fifthly, he explained why he disagreed. See paragraph 90 of the decision letter. And in doing that, he noted that the names of the interviewees had been provided. The report, the azimuth report, together with all the other application documents, were publicly available, and that there had been opportunities for all interested parties, including the appellant, to comment. So that's the background. It's like stepping into submissions, but turning to my submissions on this ground, overall, the Secretary of State's reliance on the azimuth report did not cause any procedural unfairness for the reasons given by the judge. That's at paragraphs 61 to 66 of the judgment. I'll make 4 short submissions on this. The first is the judge clearly understood this ground to have been pleaded on the basis of fairness and didn't err in saying that it boiled down in the end to a question of weight to be attached to the azimuth report. The second submission is fairness did not require the interview transcripts to be disclosed. And then the third submission is that the azimuth report was capable of being material consideration, and obviously was. And once that's established, it is a question of weight to be attached to it, and that's for the decision maker. And fourthly, there's a new contention in the pleadings, not wholly pursued by my learned friend this morning, on appeal but not below, that without the transcripts, the azimuth report becomes legally irrelevant. And I say that's not a
Legally inadmissible is all that's
Inadmissible.
saying. It would be a better word. He says you shouldn't have had it at all.
The consequence of not having the interview transcripts was that the azimuth report should effectively be set aside. I say no. The subject matter is need, that is obviously material, or at least capable of being material consideration. The fact that the interview transcripts are not provided does not suddenly make 4 volumes of material on need and relevant subject matter irrelevant. But if there were concerns that the interview transcripts or hadn't been properly represented in the findings, then that is a matter for the decision maker to say what is the quality of this report and how much weight should I put on it. So it does come to the question of weight as the judge identified.
On one reading, I think the judge might be said to be doing 2 things. 64 is he finds as a judge that it was not unfair that the transcripts were not disclosed. And if that is what 64 and 66 means, then I'm not quite sure what our role is unless there's an error in that, as opposed to inviting us to rehash that ground. And then 65 is assuming it's not procedurally unfair for the information to be available, then is it a question of weight and was the weight improper?
Yes. My Lord, the answer to those points are yes. And it takes me to my first submission, which is if you read paragraph 61, 62, and then the specific finding at 64, the end of 64, or sorry, the beginning of 64 it is, having considered rival submissions, I am unable to accept that there was any breach of the requirements of fairness in this context. And the overarching conclusion at 66, this is the last sentence, I'm not satisfied, therefore, that fairness requires the provision of the material. And so the first submission is he plainly understood that this was a fairness point. The second submission is that fairness did not require the interview transcript to be disclosed, but that was a finding of the judge below that this court should be slow to interfere with. But there is no basis on which to interfere with that finding. First of all, we're dealing with common law fairness, as my learned friend established. It doesn't point to a legal requirement for the disclosure of the underlying information. And in that context, fairness can't demand the underlying evidence to be disclosed. First of all, the azimuth report was readily available. It had been available for some time. As I said, the interviewees were identified, the substance of their responses incorporated, and participants, therefore, were able to interrogate and criticise the methodology, approach, and the lack of transcripts. And they did. And the lack of transcripts, that specific criticism, found favour with the EXA. So they made the point, it hit home in front of the examination, but the Secretary of State came to a different view. So when the appellant in her skeleton says that the azimuth report couldn't be adequately scrutinised, that isn't borne out by the facts. It was scrutinised and judgments were made, albeit different judgments between the EXA and the Secretary of State. And that's really the entire premise of this ground. Look, we couldn't scrutinise the report properly without the transcripts. Well, that point was made, and that point was dealt with. My Lords, I think I've addressed you on whether or not it's a material consideration en route to those submissions. So unless I can assist you further, that's what I need to say on ground 1A. Grounds 1B to D. Can I just begin by picking up the chronology, which is on in the core bundle, and it begins at page 19. And I just want to interpose a number of dates and events for the court, because these grounds all go to fairness, and context is obviously important in considering a ground of fairness. So if the court would look at AB 20, a bit more than halfway down the page, you see 9th of July 2020, that's when the first decision was made and the first order granted. That led to an application for judicial review, a consent order in February 2021. And so it's really on the 11th of June that the statement of matters was issued. And your lordships have been to that document, and I'm not going to take you back to that. But I do highlight that on the 9th of July, following the statement of matters, the appellant submitted representations, and that included an expert report from York Aviation. And the interested party also responded on that date, and that's described in the interested party's second respondent's skeleton argument, paragraph 9.
Does the York Aviation report, if you know, don't worry if you don't, say I can't adequately comment on the azimuth report because I don't have the transcripts, or does it not comment on it, or should I go away and read it for myself?
Well, you won't be able to read it for yourself
find it.
in terms of the papers that are before you. I might leave that question to my learned friend. Because it's not in the papers, I can't fairly answer it.
But you say that the claimant submitted objections and a report.
Yes.
And that the interested party also submitted objections, but not a report.
Not at that
if the IBA report related to the matters that were in the statement of matters,
yes.
to some extent it probably did,
yes.
but it certainly wasn't limited to them.
No.
It could have been submitted then, if it had been prepared then.
It could have. May I just come to it in the chronology, because I'm going to go briefly to it. So the 9th of July, there was a submission from the interested party. And then the 30th of July was the letter that my learned friend handed up earlier today from the Secretary of State, really previewing the second round of consultation. And in that document, making it clear that responses that fell outside of the consultation period would be dealt with as redetermination consultation and published at the end of the process. Then we get to this 21st of October, the second round of consultation. And that letter makes the same point in paragraph 13 about redetermination correspondence. And just turn that up very briefly, page 794 of the supplementary bundle. So the 30th of July, 794, 30th of July was the preview of the second round of consultation, pointing forward to the IBA report. And then this is the consultation on the IBA report that one can see from paragraph 4 on page 795. And paragraph 13 makes the same point about redetermination correspondence.
This is actually consultation on two things: the independent assessor's report and the first
And the first
consultation
round of
responses.
consultation.
All of that is the subject matter of the second one.
And the IBA report wasn't responsive to either of those things.
No, it wasn't. The IBA report was.
Was a response to the IA.
Yes, yes.
Well, it may have been, but I don't think it mentioned it at all. I may be wrong about this, but I've tried to find anything in the IBA report that says anything about the IA draft report, and I haven't found it.
Excuse me for intervening. That's simply because the IBA report was appended to another of my client's reports, and it's that report that was directly commenting on the IAA report. So this was, and it's not controversial, this was part of the package that was responding to the independent aviation assessors report.
Thank you. Well, it's just that that's not apparent from the papers we've
No,
got. I think in one of the skeletons there's a reference to a covering letter, but there's no copy of that in the papers that we've got.
No, they
I was
were
looking
before
for
the
it.
report below.
Yeah.
Yeah. So my learned friend points out that there was quite a detailed submission with a number of appendices, and the IBA report was one of those appendices supporting the submission.
Thank you.
My learned friend then showed you the letter of the 16th of November extending the deadline to the 3rd of December. And by that deadline, the interested party had submitted its response to the IAA report, as discussed. And it's important to note, and this is recorded in the chronology, on the 3rd of December, the claimant, the appellant, also submitted a further response and a further report from York Aviation. And both the IBA report and the York Aviation report were then published on the 12th of January. So that they were in the public domain by the 12th of January. Then on the, this is something that's not in the chronology, so just to interpose it, on the 3rd of February 2022, an interested party, 51012, made representations on the IBA report. And you can see that in the witness statement of the appellant, paragraph 12, which is on page 552 of the supplementary bundle. I'll just give you that reference. I don't think there's need to go there, but that's where you can see it in the papers. And then that was just before the 3rd round of consultation. And can I just point out one point on the 3rd round consultation letter? So that's the 11th of March letter that's at page 827 of the supplementary bundle. And this is a request for further information to the applicant, was at that stage, not related to the issues that we're concerned with, but you can see it at paragraph 47. But can I just point out paragraph 11 over the page? So whilst the letter as a whole was directed in the main to the applicant, under paragraph 11, redetermination correspondence, the final sentence says, interested parties who have submitted redetermination correspondence with any comments that they wish the Secretary of State to treat as formal consultation response should resubmit those by the 28th of March, so the deadline for that letter. And
The state, sorry to interrupt you, the state of affairs the beginning of 2022 was therefore that the IBA report had been filed in December. The second version of the York report had been filed around about the same time, and both of those were then put into the public domain in January. And so essentially any good submission that could be made about one of those reports could be made about the other. Right, so in other words, both sides of the argument kept on putting in material.
That was the situation. Right.
So I appreciate that the York one was not the first report from York, and I don't have in my mind particularly what the various York reports dealt with and to what measure. But if one was just to assume that the IBA and the York reports were broadly about the same topics.
They're broadly about need.
Yeah, they're broadly about need. Then the argument would have to be that both of those should have been consulted on, because it wouldn't have been fair to the interested party, for example, to take account of the York report without giving an opportunity, same argument for IBA.
That would be my submission, but I don't get that because I said there's no need to consult.
I understand that, but that in as a matter of logic, there'd be no reason to discriminate against that, or indeed an extremely important one-page letter from somebody who lived at the end of the flight path.
Indeed. Yeah. And so the next point is, well, someone did respond, 3rd of February, 5/10/12, commenting on the IBA report. They then got the letter, 11th of March, 3rd consultation, saying if you want a response outside of the consultation period, treat it as a consultation response, resubmit it.
That's not quite fair, to be fair. If they had guessed that they could reply between publication on the 12th of January and the 11th of March and had put something in, and they wanted that to be formally included, they would have to do it again. But if they hadn't realised that, and the response didn't come until after this letter, then there's nothing to suggest they can do it now.
So there are 2 points there. On the facts, someone responded before the 3rd consultation and resubmitted it afterwards in accordance.
So anyone who had done that, but nobody was specifically invited to do it, and if we accept Mrs. Dawes' evidence, she didn't realise that prospect was open to her because she read the letters and it told her what to do, and she did it all the time.
But what one could see, may I could come back to that and treat that as part of the fairness in the round, and just finish the chronology. And then on the 7th of April, and this is in the chronology, right at page 820, the responses to the 3rd consultation are published. So at that point, the 5/10/12 response on the IBA was published and became in the public domain. Now, in terms of the final IAA report, that is dated the 31st of May. And very briefly, can I just take you to that? It's 8:30 in the supplementary bundle. So page 830, that's where it begins. It's dated 31st of May, and then the table of contents at page 832 refers to the redetermination process in section 2 and first and second rounds of consultation. And the short point, and this can be illustrated by looking at page 847. And you can see on that page, first full paragraph, the appellant, her representations to the second round of consultation, and then throughout that page, references made to both York Aviation reports. And similarly, for the applicant, Page 852, by way of example, very top line refers to York Aviation, Appellant, then below the quote refers to the second round response of the applicant, which included the IBA report. So,
sorry, I'm not seeing that. Can you just give the reference again?
my apologies. So
852.
852.
314.
Jennifer Dawes is right at the top of the page, and then there's a quote, and right immediately below the quote is reference to the second round response, the applicant.
There's no actual reference. There's no explicit reference to the IBA report.
No,
But there's a reference to
the applicant's
to-
response.
that we were told included the IBA report as an appendix.
But you know this because you've lived with it and we don't. The applicant at paragraph 53 to 75, there's bits in the IBA report which touch on e-commerce, but this doesn't seem to be referring to that. This appears to be referring, if you read it, to something called the response, which appears not to be the appendix. So presumably
That's the top submission, yes.
Yes. So it's the it's not the appendix, it's the main response about which there's been no criticism. It's the appendix that there's been criticism. And you say, do you, that this relates to the main submission, not the appendix?
Yeah, no, I accept it. It's a reference to the main submission. But what I make a broader point that both the appellant's submissions and the applicant's submissions were taken into account in the final IAA.
No, I understand that. I just want to get the facts straight in my own mind, whether this paragraph beginning in their second round response on page 852 is referring to a document which consists of the main submission, or whether the reference to paragraph 53 to 75 is in some way a reference to the IBA, because we haven't got the response.
My understanding is it's
the main one, okay.
Because one of the concerns I had at one stage in this case was that the way in which the IBA report came in, not as a response to any of the formal consultations, but in the process, but outside it, may have compromised or indeed defeated what we would expect, which is that it would be taken into account by the IA. You're saying it was taken.
It was taken into account by the.
Because otherwise, the Secretary of State wouldn't have any expert opinion upon it, and would be working
So
in a somewhat difficult position.
So the 2 points that I make in response to that is, first of all, it did come in response to the second round of consultation, and secondly, it was taken into account in the IAA final report.
But only what you've showed us for so far, the main bit, and only in relation to e-commerce sales where the independent assessor agrees with the data presented. Not criticising the data in either the main bit or the appendix, but saying broadly the e-commerce sales data is correct. But there's no robust evidence to demonstrate that e-commerce growth is going to be followed by an increase in air freight volume.
I mean, it's taken into account the applicant's response and representation is taken into account in a number of areas. So in e-commerce, as your Lordship is looking at the moment at 852, and that runs through to 855, and there are a number of references to the second round representation. But again, the main submission, so at 854, halfway down the road, is reference to paragraph 57. It's the paragraph that starts in their second round representation.
There's a bit of a difficulty about this, isn't there? Because on page 849, the IA addresses quantitative need for development and explains, I think, that what's been addressed is the topic set out in the statement of matters. In other words, changes since 2019. And the IBA report is not devoted to that, otherwise it would have been submitted in the first round. It covers that, but it broadly says there's a lot of need, and there will be a lot of need.
Yes, but it is a response to the independent assessor's report that is assessing.
Well, it's a reaction to it, perhaps.
Yes.
But my point was earlier that it's not responsive. It may have been prompted by it, but as there's nothing in it that says, well, we've read in the draft report this and we disagree for these reasons, it's not responsive.
No, it's not a point rebuttal, but it is supporting the main submission that the second respondent makes in response to the IAA draft report.
I mean, it's funny because in the end, the Secretary of State said, and I'm very much glossing here, the IVA report said all of this, and it's pretty much the same as the applicant said the first time around, so it's more of the same.
So
it's sort of discounted on that basis, and that's sort of in your favour, because it's not saying this is fresh material that changes my mind, it's more of the same.
yes, when we look at the decision-making letter in the context of, for that reason, construing Rule 19, I will be saying it doesn't form a material part of the reasoning.
But in one sense, this doesn't really help because it's very interesting that the independent assessor saw it. But the question here is, should Mrs. Dawes have
Yes,
seen it?
well,
That is what we're here to
Yes.
discuss.
And may I turn to that question then, in the context of Brown 1B? So this is the whether or not there was error in the construction of Rule 19, and the appellant's point that Rule 19 applies generally after the close and Rule 20 is supplemental to it and not set at stage. So, and in coming to that conclusion, my learned friend says that the judge erred in treating section headings as determining the scope of the relevant provision. The learned judge didn't err in the statutory construction, and his construction discloses no errors, and his reasoning at judgment paragraphs 71 and 72 is my submission correct. Dealing with the headings point briefly, it's clear when one looks at paragraphs 71 and 72 that the judge's conclusions were based on a number of factors. So that in 71, he says that the headings, he bases the judgment on the headings and the provision of the rules themselves. So that's four lines down on the basis of the headings and the provision of the rules. And then at 72, he has regard to the statutory context in which the rules operate and the mischief.
Let me stop at 71. Forget the headings for the moment. It's clear that Rule 19 applies after completion of the examination, yes, and the submission of the XA's report to the defendant, yes, prior to decision making. Right. So that would require decision making to mean the decision that in this case got quashed. What possible good purpose is there in interpreting the rule in that way?
My Lord, can I just ask which sentence?
Paragraph 71.
Yes.
4 and 3 lines from the bottom. I'm sorry, slightly above that.
Well,
Prior to decision making, 4 lines from the bottom.
let me come back.
I understand when it starts, the responsibility
Yes.
here. But what mandate, either in wording or in good sense, could there be for it stopping just because your decision got quashed?
Well, it's important, one has to interpret the provisions as they are on the page.
But they're not on the page. That's the point I'm making to you. There's nothing on the page in Rule 19 that says this is when it stops.
No. So one has to then look at the context. And
Well, the context is to try and achieve a fair system.
yes,
I mean, it's in planning terms to try and put a system in place which reflects anybody's idea of what's a fair system. Right, so, I mean, just leaving aside the words for a moment and approaching it from that standpoint, what value could there be in saying that Rule 19 applies only until your decision gets quashed? You'd expect that you'd be asked to do better next time, not less.
It applies up to the point the decision is made, and then there's a distinct rule that deals with after quashing, Rule 20. And there's a good reason for that. Rule 19 deals with particular circumstances. It addresses, as is clear, the period post-examination. It's before the decision, and it applies where the Secretary of State intends to reach a different conclusion from the examinator.
Yeah, but so he wants to reach a different decision twice. Why shouldn't it apply to the second time in the same way as it applied to the first time he wanted to reach a different decision?
Because in Rule 20, the situation is different. And may I just finish?
No, I understand why it said it's different,
Yes.
but at the moment, I don't agree.
Yes.
Speaking for myself, why should Rule 20 not be supplemental to Rule 19, taking account of the special circumstances that arise on a reconsideration,
I say it's.
rather than a replacement?
I say we've got to look at what the statute says, the provisions there. They are, on the basis of language, take a different staged approach that doesn't overlap.
It says it should be after the completion of the examination. It doesn't say it should be after the completion of an examination until you make your first decision.
Yes. But one has to look at what after means in the context of the two provisions. And if one looks at Rule 19, if we take it up in
Yes.
tab 2, Rule 19 was after completion, and I accept that that can go on until post-decision and be applied.
So what it can go on indefinitely, provided your decision isn't quashed.
On the basis of those words, but you have to read the words in context. And once you read the words in context, that isn't the situation.
How can you rely on the making of a decision which has been quashed as a stopping point for the application of this provision?
It's not me relying on it. It is the way the provision.
Well,
the provisions.
does it make any sense when it's not spelled out that that's the end point? An unlawful decision which has been erased from the record for that reason, you're telling us, is intended by the legislator to be the stopping point for this obligation of fairness. Seems odd.
That is the submission for these reasons.
Right.
First of all, in terms of the structure, Rule 91 and 2 deal with the obligations on the examining authority at the close of the inquiry to report and recommend. That is completed and no longer applicable post-decision.
But there hasn't been a decision. There was a decision, but it's an ex-decision. It's a dead parrot. It's been quashed.
But paragraph 20 is engaged in those circumstances, procedure following the quashing of the decision. And so that is engaged when there's a quash decision. And it provides a new and distinct procedure.
But why are they complementary? You insist on dealing with this in time matters, but the substance of each obligation is different. 19 is you must notify and in certain circumstances allow representation if you're differing from the examining authority on a fact or if you're taking account of new evidence. 20, there's been a quashing and then you're doing something quite different. You're asking for general representations for further consideration of the application. Take the morning after the quashing, and I don't know whether this case or not. Say the Secretary of State, up until it was quashed, had said, I disagree with the recommendation because I think they got the facts wrong, and it's quashed. the obligation to say in the new letter that I disagree with you because the facts are wrong must surely be just as important second time round as first time round, because nothing has changed. There may be additional things to do with the quashing. If after the quashing, and there's been no 19.3b letter, the Secretary of State does what happened in the Gladman case and says, well, actually, I think I'm going to have a look at the Margate website, and he discovers all sorts of things about the airport that he didn't know before, and he thinks, gosh, that puts a different complexion on it completely. Why, if there are factual matters or disagreements which may arise at the date of the quashing or be generated first after the quashing, not be caught by 19, albeit that 20 deals with a different set of things?
I've made the structural point, but in terms of why it's set up like that, it's because of the particular factual scenario at the Rule 19 stage. And as I said, it's post-examination, but before the decision, and before any participant knows the recommendation of the examining authority. And if it is new evidence or a new fact, those participants do not know about those the new evidence or facts. And so what 93 requires the Secretary of State to do is inform interested parties that he's taken into consideration new facts or evidence, and by that reason is disposed to disagree. And that is at the stage where interested parties know neither the fact of disagreement, the recommendation, or the new fact or new evidence. In the Rule 20 situation, the Secretary of State is required to provide the statement of matters, and it initiates a new procedure. And as here, there's publication of the responses. And so here, in terms of the IBA report, that was new evidence that was known to the interested parties, alongside the recommendation and alongside the inclination of the Secretary of State, as exhibited in the first decision letter, to take a different view. So parties had all the information that Rule 19 is trying to ensure they get if new facts or information.
But yeah, they didn't. I mean, assume for the moment that the IBA report was new evidence, and it was fundamental to the Secretary of State's decision. So they said, gosh, yes, I see now, these figures prove that we need a new airport and need it quickly. And that came not at the time of the quashing, but in the course of the negotiations. What substantive reason would there be for 19.3b not applying then? The whole thing has changed now. Why doesn't it apply? It would have been the same in the first determination if something had emerged in the consultation of the first determination that was new and was a game changer.
Well, it's that structural reading of the two.
It's the structural reading.
Yeah.
I mean, apart from the fact that as you read it, you say that's what it says, is there any other reason that you want to fall back
Well,
on?
and those contextual reasons, sir.
What's the contextual reason?
The fact that the knowledge is different in the interested parties at the time that Rule 19 is engaged, whereas post-quashing, they know the recommendation, they know the new evidence.
No, they don't know the IBA evidence. That's the whole
It's in
point.
response to the statement.
Yes.
Yes.
One of the things that puzzled me about the judge's approach to this, which I think was accepting your submission, is this. One explanation of Rule 19 is that the normal course would be for the examining authorities' recommendations to be accepted. If, however, the Secretary of State is going to take a different view or rely on other evidence, then that normal expectation will be disturbed, and people have a right and fairness to have their say about it, be told. On that interpretation, it doesn't matter whether the report's been published or not. The fresh evidence which is going to change the outcome is the key factor.
Well, I think Rule 19 is accepting that the Secretary of State is enabled to come to his own views. It doesn't have to accept the recommendation. It is only where new facts or evidence arise that people haven't had the opportunity to comment on.
Well, quite. But my point is that really, in common with my lords, it seems to me it's hard to construct a material difference between the two phases. You rely very heavily on the fact that, as a matter of fact, rather than as a matter of law principle, the examining authority's report has not been published in the period prior to the first, in this case, unlawful decision. That's really your main point.
It is, yes, it is. It's that contextual difference, and the fact that Rule 19 deals with the actions that the examining authority have to take, as well as the Rule 19.3, and those are completed post-examination and not revived by a quashing of the decision.
And to make a bad day worse, why then in 265 do the Secretaries take the different view?
Well, I say the judge is right.
Just a mistake.
It's just a construction.
The light had not yet shone upon the building.
But it does. I mean, the Secretary of State applied his mind to whether, as a matter of fairness, through the prism of 19.3, he didn't need to go back, and it was right to do that as a matter of general fairness to consider that.
All right, well, this has all been about whether you've got any hurdle to jump in
Yes.
relation to IBA. Let's suppose you have, and see how you get on with that.
So ground 1C. The 2 points that are made. It said that the judge erred in reaching his alternative conclusion in 2 ways. One, that for the purposes of Regulation 19.3b, the report need only be A, not the reason for disagreement. And then he was wrong to treat the IBA as not making a difference to the defendant's conclusions. My lords, on the construction of Rule 19.3b, I think my learned friend came close to accepting that when you construe the words "and is for that reason disposed to agree," one is looking for something that has a material impact on the decision. My Lord said played a significant part. My Lord Justice Lewis said causative bearing, and I accept that's my submission. That is a proper interpretation of the requirement. And insofar as Mr. Justice Jay went further than that, in paragraph 45 of Gladman, that should not be followed.
And hence 265 was really making more or less the same error. Because on my view of 265, the Secretary of State was accepting the expansive version of Mr. Justice Jay's interpretation.
I'm not necessarily would read 265 to agree with Mr. Justice Jay.
Well, just to explain the point, the Secretary of State says that he, unless addressed in the letter above, he doesn't consider the redetermination correspondence raises any new issues that are material to his decision on the development.
Yes.
So that's a more generous view of what 19 requires than the position that it has to be determinative, or it has to be A or B reason. It's just some materiality.
Well, I accept that it's not quite clear what he's saying, but the proper reading of Rule 19 is that for that reason means it must have a material bearing or a significant part. So then the question becomes, well, did the IBA report...
Can I just be absolutely clear, because we're glossing over 2 things. Does it have to be the reason, the sole reason, the prime reason, or could there be one or more reasons, which is a reason, but it has to be a causative reason, not something that bears on the process that you might want to look at?
I accept it doesn't have to be the sole reason that has to have a material bearing or causative effect. So does it have a causative effect? Does the IBA report have a causative effect on the Secretary of State's reasons for disagreeing with examining authority? No, for the reasons given by the judge in paragraph 73. And to make that good, one has to look at the decision letter and how it deals with need. On page, starts on page 410 of the core bundle. And the conclusions on need spread out over 95 paragraphs, so it's lengthy, and I'm not going to seek to take too much of it. But can I just highlight that need begins page 410, and the first subheading on 411 is relevant policies and national policies on 412. And the conclusion in relation to national policy begins on 417. And ultimately, the conclusion is that paragraph 72, at the foot of 419, satisfies the principle of development is supported by relevant national aviation and aviation planning policies. No mention of IBA reports get there. Then local plan policies, again, over the page, page 78, paragraph 78. The principle of development, 5 lines down, accords with the use of the site as set out in local policy. Nothing to do with the IBA report there. So where the IBA starts to come in is under the heading air freight demand and forecast. And I'd ask your lordships to read that section outside of court. But what paragraphs 79 to 88 are doing are summarising the positions of parties examining authority and the evidence. And it's in that context that paragraph 84 that the IBA report is dealt with. And the ultimate conclusion is that the Secretary of State is of the view that the data demonstrates a sustained growth in air freight demand. And as my learned friend says in his skeleton argument for the second respondent, paragraph 51, that wasn't controversial. What was really an issue was how demand was to be met, not that it would exist. So what you really need to do is look at the conclusions. And in the conclusions, paragraphs 89 to 94, and your lordships will read this and have read these paragraphs, but the focus is on the azimuth report, the preference for the qualitative approach based on the interviews rather than historic trends and forecasting forward. And there's no reliance on the IBA report at all in the conclusions. So ultimately, at paragraph 91, last sentence, the Secretary of State says, he therefore afforded the azimuth report substantial weight in the planning balance. Then capacity, and your
hold on, we've got that peculiar sentence, paragraph at 92, which refers to industry and other news that supports the e-commerce and air freight demand is increasing. It is also the case that the IBA said that air freight demand is increasing. But 92 appears to be referring back to 85 rather than the IBA. I don't know whether by luck or judgment.
That's my understanding, is it's referring back to 85. And the reference is made there rather than the IBA report.
And you say in any event, it's realistically subsidiary, not the reason.
Yes, the driving force there is clearly the azimuth report. On capacity, on the next page, same page, 425, there is reference to the IBA report. My learned friend took me to this in paragraph 100. And that is in the context of the conclusions. But what the Secretary of State is saying there is that he notes the IBA report also contends that reliance. There's really in a cooperative nature that it's relied upon there. Then on 428 locational factors, there's no reliance on the IBA report. And e-commerce on page 429, there is reference in the summary of the evidence on page paragraph 109 and 110, but no reference to the IBA report in the actual conclusions of the Secretary of State. Those are the only times the IBA report isn't mentioned. And as my Lord Justice Lewis pointed out, my learned friend, it's important, and I say the most important, to go to the overall conclusions on need at 433. And that's at paragraphs 125 to 128. And the points that the Secretary of State relies on in short are that there's the azimuth report shows a demand for capacity, that he can't give weight to future capacity at other airports due to uncertainty. He prefers the qualified approach in the azimuth report, and the proposals accord with the national policy to make best use of existing airport infrastructure. That's 127. At 128, he makes a number of short points. It would release capacity to address demand for air freight services, help with supply chain resilience and general aviation. So, in the overall conclusions, there is no reliance on the IBA report. So, my overarching submission is that if Rule 19 does apply, the decision to grant development consent was not by reason of the disagreement with the EXA and decision to grant development consent. It was not by reason of the IBA report. That just isn't supported by fair reading of the decision letter as a whole. Then I'm conscious of the time. So in my skeleton argument, I just point to paragraph 44 firstly. And that just makes the point that the judge's conclusion that the defendant was disposed to disagree with the EXA's recommendation was his appraisal of the weight to be attached to the azimuth report is a inference from the facts or finding of fact that this court should be slow to interfere with. And I refer there to the Phage decision and then also to Smet Properties because Mr. Justice Bug is experienced. And And then I will go on to deal then with ground 1D. But in doing so, can I just ask the court to bear in mind paragraphs 49 and 50 of my skeleton argument, where I say that if Rule 19 was engaged, then there was substantial compliance with it and no material prejudice. And that's because of the reasons that I'll deal with under procedural fairness generally in ground 1D.
When you say interested parties could and did comment, is that one interested party or is it more?
On the IBA report, it is 1, 5, 10, 12, but that one demonstrates the principle.
Yeah. When it says interested parties could and did, but one of them did.
Yes. Yeah.
Sorry to be accurate.
No, it's absolutely, you're absolutely right. So on ground 1D, there's two questions that my learned friend raises, and that is, did the judge apply the wrong fairness test? And I think I could deal with that briefly because he accepted that it all boils down to the same thing, that it's whether or not it was so unfair as to be unlawful. But just in passing, can I ask the court just to take up paragraphs 75 and 76 in the judgment? So the general, a number of occasions, the judge, 64, 66, ultimately 77, simply comes to the conclusion that there was no unfairness. He's not applying an extra hurdle in terms of merely something went wrong, but clearly and radically wrong. At 76, it is worth noting in the context of the judgment in Bloomsbury that where he's dealing with clearly and radically wrong, he is addressing the consultation process as a whole. Should there have been an express opportunity to comment on the IPA report? He then goes on at 77 to deal with the particular circumstances in relation to the appellant. So the main point pertaining to the particular circumstances of the then claimant is also of significance and applies their fairness test that you can see at the end of paragraph 77. So I think read fairly and not as an examination paper, the judge doesn't make an error of law. In any event, it is agreed that the test is whether it was so unfair as to be unlawful. And there's a clear answer to that. No, it wasn't.
It's always odd when a test is put in that way. I mean, what it comes to is this: unfairness is unlawful if it's really so unfair that it's unlawful. I mean, it's not a very helpful test, is it?
No, it isn't. And
we get it in other areas of law, and that way of putting things is circular.
I'll accept that, and that is why the courts have, in circumstances where you're looking in particular at the whole of the consultation process, made reference to clearly and radically wrong, because one isn't looking for perfection, one is looking for unfairness, which is a different concept.
And the oddity is, of course, although it is true that the letters refer to redetermination correspondence, what they say is, we're not going to consider it unless you resubmit it expressly and say it's to be taken into account. And of course, the one thing that couldn't happen here would be an opportunity to do that, because there never was another letter saying, and you can also make comments on the second one, and if you tell us by a certain date, we'll treat that as a representation.
Yeah. So the letters say, if you want to be treated as a formal consultation response, put them in at the next consultation. What I don't accept, they say, is otherwise we won't take them into account at the end of the process. What it says is, Otherwise, they'll be treated as redetermination correspondence and published. And implicit in that is that they are being taken into account because they're part of the published matrix at the end of the day of all the information that's before the decision maker and the public. But in this case, there was clearly no unfairness because it was made clear throughout the process that the Secretary of State, I say, would take into account not only the consultation responses but predetermination correspondence. Secondly, both the appellant and the interested party put in reports, the IDA, I should say your aviation, and then the IDA, interested party. Both of those reports were published in January 2022, so 7 months before the decision was taken. And it's right that there was no express invitation to comment, but there's nothing in the rules to require that express invitation. And nor is there anything in the Secretary of State's letter during the redetermination process that precludes the submission. Really the opposite, because he says, I'll publish redetermination correspondence at the end, you want it as a full consultation response, submit it. And we've got 5, 10, 12 commenting on the IPA report. Those comments were published. Neither the appellant nor the interested party commented on each other's report. And they were both taken into account in the final IAA report, the Independent Assessors report. So all of those circumstances together can't be so unfair as to be unlawful. So unless I can assist you further, I will move on to ground 1E, which is the capacity point.
Thank you.
On that, I have 3 principal submissions. First is that the advice of the Minister is not that the future capacity at other airports is legally irrelevant when it's read fairly. Secondly, there's no material distinction between the draft decision letter and the final decision letter. And thirdly, however the advice of the Minister is interpreted, there's no difference whatsoever to the outcome. So, in terms of the first point, that the advice to the Minister is not that future capacity is legally irrelevant. The advice must be read fairly and as a whole. And it's not the mechanistic approach taken by the appellant, 4 or 5 references. It's not a counting exercise. The language has to be understood in the context it's used. And can I ask you to take up this supplementary on bundle and go to the submission, which is page 890 of the bundle, page 352 PDF. And your Lordships have seen this before, so drawn on it. Can I just make the first point, page 892, your Lordship saw paragraph 5 of the cover note, and that's a reference to not relevant to us. My Lord Justice Lewis said, it doesn't really tell you much there. But in construing these documents, you have to have regard to what was before the Secretary of State, the Minister. At 892, you can see the list of annexes. And that Annex B included the draft decision letter. So the draft decision letter was part of the advice and submission before the Minister. And then in the submission itself, on page 893, and it's paragraph 5, a number of areas where we disagree, and over the page on 894, capacity. you've seen that, but that has to be interpreted in context, and it specifically refers to the draft decision letter, paragraphs 95 to 102. So to understand what is meant by not material, one has to have in mind the context of those paragraphs, 95 to 102. And turning that up in the draft decision letter, your Lordships have seen paragraph 97, page 926. And the first sentence shows he's talking about potential for all existing airports to expand in the future to increase capacity. And then it's the very little weight 2 or 5 lines down. And then can you just note the last sentence? It's therefore not possible to say with any certainty whether capacity from plans setting out growth aspirations will result in actual future capacity. And then paragraph 102. Second sentence is dealing with future plans and potential growth, so the same as 97. And then it says, as set out above, such capacity is not material. So as set out above is a reference back to 97 and the very little weight. So not material has to be construed with those with that in mind. And as Lord Justice Lewis said earlier, not material can mean legally irrelevant or not have a material bearing on the decision. And that linkage between very little weight and not material shows it's the latter. It's not much material, not much bearing on the decision. So when the documents are construed as a whole and fairly, it's clear that they were treating future capacity as capable of being legally material, but didn't think it had much bearing for the reason of uncertainty.
Well, any proper advice to a minister in these circumstances, if the material, try and avoid that word, if the documents that were presented to the minister included matters that the minister was not entitled to take into consideration for legal reasons, would have to say so.
Yes. Yeah, well, you wanted to expect it.
I mean, with all this parsing of the letter and so forth, it seems to me that one of your strong points is that that is a dog that definitely didn't bark.
Yes. The second submission is there's no material distinction between the draft and the final decision letter, and your Lordships went to the comparison version. And page 1016 of the supplementary bundle, there's a change from is unable to take into account capacity to unable to place weight on capacity, which clearly fits in with that earlier draft letter, which is material consideration, but not of much interest here.
You do have to read the whole sentence. It's not he's unable to place weight. He's unable to place weight on capacity that airport operators have not indicated they intend to and are able to create.
Yes.
The whole sentence has got to be read.
Exactly. So that's the reason.
The reason that it's because of the reason that it's irrelevant, not because it is per se irrelevant. It's your submission. Yeah.
So in truth, when it's read, and then you've got paragraph 102, which says capacity is not required to be taken into account, i.e. obviously not material, which is fine. And there's no suggestion that there's any error in the final decision letter from the appellant. It is simply the advice and the construction of the advice on which this ground is founded. And then the last point is simply this, that however the advice of the minister is interpreted, it makes no difference to the outcome, because it's either very little have the Lord Hoffman and Tesco's store saying a distinction between very little weight and no weight at all is a piece of scholasticism that would do the law no credit. It just simply doesn't feed into the ultimate result. Unless I can assist you further, those are my submissions.
No, thank you very much indeed, Mr. Weston. Yes, Mr. Humphreys. You can stand anywhere so long as you're under one of them. That'll do, guys.
My lords, clearly, in terms of time, I'm somewhat limited, and therefore, obviously, I will adopt the arguments of the
Perhaps, could we start with identifying what, if any, other differences between you?
I think they are the same. I will add certain points and emphasise perhaps certain points, but I will try and keep things brief, because I will just dip into certain points. I think you referred to as island hopping earlier. My submission may seem disjointed, but
No, that's because you're following.
Indeed.
Yes.
My lord, ground 1A, first of all, I'll deal with this, I think, really pretty briefly. In my respectful submission, the judge in the judgment identifies, in effect, in his paragraph 63, 64 and 65, three elements. Firstly, he makes the point that there is no requirement, no statutory or regulatory requirement to disclose confidential information. There doesn't seem to be any challenge to that. And it's in that context that he then deals with, obviously, the second point, which is the appellant therefore relies on arguments of fairness. My respectful submission, the judge deals with the appellant's arguments on this issue, the fairness arguments, clearly in those paragraphs 63 to 65, and he comes to a clear conclusion, see it in paragraph 64, that the decision is not unfair. My lord, as to fairness and how he has come to that conclusion, clearly there are a number of elements to this, but as has already been pointed out, the material here, the interviews, was not material that was available to the Secretary of State, but not everybody else. The material was summarised in the original Azimuth report and was available for comment and was challenged and criticised by other parties. And third point I just stress, and my friend has covered this, so I can perhaps deal with it fairly briefly. It is important to emphasise that the Azimuth report was not just some interviews. It was a 4-volume report, of which you only have parts of Volume 1 and Volume 2. The judge, at his paragraphs 8 to 9, sorry, 5 to 8, I apologise. 5 to 8 does summarise the three volumes of the reports I won't take you all the way through that, but I will just draw your attention to paragraph 8. It's here that the judge, having referred to the recommendations in volume 2 of the report, on page 113, refers to the quantitative assessment. That was what my learned friend took you to in the examining authority's report at, I think it was bundle page 717. It doesn't mention volume 3, but that's what he's talking about here. It says derived from the contents of the interviews, Azimuth then arrived at recommendations, firstly in relation to the opportunities for Manston Airport to attract aircraft movements, including those arising from a lack of available slots at other airports in the southeast of England, bumping of freight from passenger aircraft, so-called belly hold security issues associated with outsized cargo. So this was the sort of market that was being described in the interviews. Large items that couldn't go in belly hold, things that are bumped. This is in paragraph 7. Then paragraph 8, fourth line, it says, whilst it is not set out in detail within the report, in answers provided by the interested party, that was my clients, to questions on need posted during the examination, more detailed breakdowns were provided in respect of, for instance, the particular market sectors, the assumptions which had been built into the forecast as to the number of aircraft movements and the volumes of freight which were forecast to be moved from Manston Airport. The demand forecast showed that the volumes of freight would increase over the course of time to 17,000 freighter movements. That's the forecast. So the point I'm emphasizing there is that the role of these interviews of 24 people should not be overstressed. These were one element was looking at the nature of the demand that might arise, and it was talking about fresh goods, for example, oversized things.
Right. So the withheld bit was, if it was anything, one string to the bow.
One string to a very large bow, and the forecasts were in volume 3. The forecasts in volume 3 are not directly challenged. No one's saying that that is unreasonable or that no reasonable specialist forecaster couldn't have come to that forecast. But what she did in that case, we would say perfectly reasonably, is she talked to local people in the market and said, well, look, what are the sort of things that might come forward if there was a cargo airport in this location.
Just so I'm really clear, was that table in volume 3 a direct conversion simply of the 24 interviews responses, or is it a conversion or a calculation from the 24 interviews and other things as well?
The 24 interviews, I won't take you back to it, but it's those sections from
Section 3,
page 602, I think, onwards. When you look at those questions, they're very generic questions about the nature of the market.
I understand that mine's
What
much
the
more
consultant
limited
then did-
factual question.
Yes,
There is a table in volume 3 which we've been shown,
yes.
and it said that that followed on or volume 2 led into it, and I just simply want to know whether those figures are based solely on answers to questions given by the 24 interviews, or whether it's based on other matters as
No,
well.
it's based on professional judgment. The expert who produced the Azimuth report, who's a lecturer at Cranfield University or consultant there, does other work, looked at that type of market and then built up a forecast. Look, in year 1 we could probably get this. Why was it necessary to do it in this way? Most forecasting at airports looks at a past trend, looks at econometric matters and extrapolates forward. Manston has been closed for a very long time now. It's not possible.
We understand the point with using historic data. We know why
Exactly.
she said you should go to qualitative data.
Next point, I think the question was raised, did the York Aviation criticise the Azimuth report for not disclosing? Yes, paragraph 5 of my skeleton actually makes this point. Paragraph 5, the very last sentence, talking about all the various reports that went in. last sentence says, York Aviation inter alia criticised the interviews informing the azimuth report, and a reference is given at footnote 33. There's no real need to look at that now. That was one example, and indeed there was a lot of evidence given during the examination of various parties, and a lot of scrutiny given to these figures, and that's indeed why the judge rightly reports that a lot of additional information was requested and supplied about the forecast. My Lord, beyond that, I won't say anything else on ground one.
Before we leave York, just in order to tie up a loose end, you made an application to rely on.
Yes. I was going to come to that when it becomes relevant.
Right, it will. Okay, it's still in play.
Yes, it will definitely become.
Okay.
It will definitely become relevant.
Thank you.
So that's everything on 1A. 1B. We say that the judge was right to draw a distinction between rules 19 and 20, as he did in the judgment of paragraphs 71 and 72, and I'll express my own views on what that distinction is. Rule 19, my Lord, 19.1 and 19.2 are requirements for the examining authority to write a written report on findings, conclusions, and recommendations. 19.3 is the particular provision we are concerned with. If one asks oneself, what is the mischief that 19.3 seeks to overcome? It's fairly clear from the words and what the Secretary of State is required to do. Firstly, there has to be new information that he has taken into account. And secondly, by reason thereof, he's disposed to disagree with the recommendations of the examining authority. The mischief that Rule 19 is dealing with is A, the examination having closed, nobody else will know that he has taken into account new information. It's an entirely closed box. That new information could be all sorts of things, some new report, some new policy statement. So he needs to disclose that. But secondly, he needs to tell people, A, what the examining authority's recommendation is, and that he is minded to disagree with it. They don't know that. And therefore, Rule 19 is dealing with the mischief that without knowing those things, people just simply do not know how to make representations to the Secretary of State. They don't know why they are being asked to make representations. That is entirely different once the decision has been quashed and Rule 20 applies. At the Rule 20 stage, the Secretary of State is specifically asking parties for new information. All the information is new information. Everything is new. None of it was considered during the examination.
Is that right? I mean, the letters say specifically that everything that was taken into account before will be taken into account again.
Yes. What I mean, none of the information at the redetermination stage was considered during the examination. It is new, and that's what Rule 19 is talking about, new information since the close of the examination. At Rule 20, everything is new. Every single piece of information that comes in is post-examination information. And of course, the Secretary of State does not need to explain what the examining authority's report is, because the examining authority's report has been disclosed and would have been there as part of the quashed
But this
decision.
is new material that came in during the second stage of the consultation.
Oh, sorry.
This is, the IBA report is new material, that new evidence that came in at the second stage consultation. Nobody would have known that at the date of the letter after the quashing, the Rule 20 letter.
My Lord, no, I'm making a slightly different here, distinguishing the point from Rule 19. So it's all of it is new information. All the information submitted, York, IBA, all the other submissions are new information in that sense. They were not before the inspectors. And the examining authority's recommendation is again known. Now, in Rule 19, because the recommendation is not known, the Secretary of State needs to say specifically, look, I am minded to agree with this recommendation. That was what the recommendation was. That's just not necessary after the quashing. And indeed, each of the Secretary of State's letters, so the statement of matters, second consultation letter, and the third consultation letter, the last paragraph on each of them makes clear that the information that is being requested is without prejudice to whether or not the Secretary of State grants development consent. In other words, the Secretary of State is implicit in the whole Rule 20 process with all of this new information that the Secretary of State may come to a different decision from that recommended by his inspectors. Of course it is, because everything, all the information is new at that stage, and the references to that. Again, I won't take your lordship there, but paragraph 13 in the statement of matters, which was Authorities Bundle 793. Paragraph 14 in the second consultation letter, that's Authority Bundle 796, and paragraph 12 in the third consultation letter, 8 to 9. In other words, Secretary of State is making it absolutely clear there that I may depart from the recommendation of the inspectors. Now, in that context, the very mischief that Rule 19 was designed to overcome, new information that people don't know about, and differing from a recommendation that they don't know about, it just doesn't exist anymore. And that is why Rule 20 is its own self-contained complete procedure to deal with a completely different situation. As I say,
Could you
the mischief
just
doesn't exist.
talk us through, because we haven't been giving such attention to the first decision.
Yes.
So just talk us through what happened from the receipt of the XA's examination. What did the Secretary of State do then?
I cannot remember if we went through.
Did the Secretary of State do 19.3?
Was there did they ask for further information of our?
I'm being informed.
Just so everybody hears.
I'm being informed. No, there wasn't.
No.
It was 19 process.
No, because there wouldn't have been any need to at that stage. None of the limbs were triggered.
Well, it would have depended whether at that stage the Secretary of State was minded to took into account information and was minded to disagree. He did disagree, but he hadn't, which is what I couldn't remember. It was a few years ago now. I couldn't remember whether he'd taken into account new information.
Right, so I appreciate that what happened in a particular case doesn't tell you what the rule means,
No.
but I'm just trying to situate your submission in the context of a real-world situation such as we have here. There was a completed examining authorities examination. The Secretary of State, without, as it turns out, going through Rule 19.
He didn't take into account any more information. He just made his decision.
Yes, well, as it happens, he differed either because he didn't agree. It's not just he had anything new at that stage,
No.
but he differed for reasons that seemed good to him. At that stage, there was dispute and there was a proceeding, and that just went away without 19.3 having occurred. So that's what actually happened here, for what it's worth. And on we went. And so, what was there in the examining authorities' examination still existed in the
Yes, the examining authority's decision existed, and
after the quashing.
because
It
it's
still
known,
existed and
it's
was still
known,
in the possession of the Secretary of State
and the public at that stage.
and of the public, that at some point, at what point does the Secretary of State say, I'm minded to disagree with this?
Well, the Secretary of State then started the Rule 20 process.
Exactly. So by those means, 19.3, you say, can simply be bypassed.
Because the mischief that 19.3 was seeking to overcome, i.e.
No, it isn't, because, I'm sorry to speak over you, but it's not just that the material is you don't know what it is, then you need to know what it is at some point. It's that you don't know that the Secretary of State is minded to disagree with it, and what the reasons for the disagreement are. That's what 19.3 brings out.
Yes, exactly. But by the time we get to the quash decision and Rule 20A, the Secretary of State is asking through the state of matters for information on a new information.
Yes, but he's not giving 3B1 notifying all interested parties of his disagreement and the reasons for it.
Yes, but what he's...
So why shouldn't they have that?
Well, because what he's doing at this stage is telling them in each of those letters, because we've now entered the Rule 20 process, that look, by the way, this is without prejudice to whichever way my... But
that's not notifying
goes.
them of his disagreement and the reasons for it. It's just saying, here are a few things I'd like to know more about.
Well,
I mean, you know this far better than I do, but it just seems to me to be completely counterintuitive that after a quashing, the interested parties, I mean, you might have been on the wrong end of this. I mean, it happens you weren't, but you might have been. And so it just seems to me to be completely counterintuitive, to use a polite word, that you should have been deprived of the opportunity to know the Secretary of State's disposal intentions and reasons for them. What's gained by
my lord, in the sense, I have made my submission to you. My firm submission is that the particular mischief that Rule 19 is directed towards is the fact that at that stage people do not know what
right. If that was all the rule was there for, I could begin to get on board that submission, but it doesn't seem to me that that's what it's there for in totality.
And the other parts, I mean, it's not even suggested that the other parts of Rule 19 are engaged following quashing. In other words, the 19.1 and 19.2 require the examining authority to write a report. Now, if there's new information, they're not asked to write a new report. And my respectful submission, why is 19.3 engaged post-quashing, but not 19.1 and 19.2?
Because it begins with the words, if after the completion of the examination.
But that's also what 19.1 and 19.3 both say that.
It does. Can I just ask this as a matter of fact? We've been told that the practice of not publishing the XA report is no more than that. It's not prescribed in any way. Is that correct?
I don't believe that. I believe that is correct. I don't believe it is prescribed anywhere. It's never done.
It's a common way that government decisions are made, to publish the report at the same time as the decision. But it's just a practice, and it's not expressed as part of this process in Rule 19. So the point that was made on behalf of the appellant that the Secretary of State would be quite entitled to depart from that practice, and things would look different. And your argument about ignorance of what the XA has recommended would disappear is a sound one.
Yes, in principle. In a sense, Rule 19 appears to proceed on the assumption that people don't know, because the Secretary of State is required to tell them that he's minded to disagree with the recommendation, and therefore is the case that he must disclose what the recommendation is at that point in order to make clear that he disagrees with it.
If you look at the words of 19.3, they are puzzling words in some way. 19.3a differs from the examining authority on any matter of fact mentioned in or appearing to the Secretary of State to be material to a conclusion. So that's not about the recommendation, we stick with those words. And we've got conclusions on a number of issues, including need. Now, there's not a difference from the examining authority on any matter of fact.
No.
He simply gives azimuth weight, notwithstanding not having the transcripts, and the examining authority didn't. So at that stage, it's not clear that that requirement is met. But anyway, assuming it was met, what he must do under B1, or following B1, is notify the interested parties of the disagreement and the reasons for it. That could be in advance of the decision, or it could be in the decision itself. Little 2 is different because that goes back to B, because when you've taken into account any new evidence or new matter of fact, and for that reason you're going to disagree with it, you can't come to a decision without notifying them of the disagreement and the reasons and giving them an opportunity in respect of any new evidence or new matter of fact.
Yes, and Roman 1 and 2, I think, obviously joined by Anne, so he must notify them of the disagreement and the reasons and give them the opportunity. And it's that first part must notify them of the disagreement and the reasons and disagreement with the recommendation. That is what is important, because they simply don't know. I've practiced in this area almost entirely. People just simply don't know what the recommendation is.
They only need to be told in advance, legally, of the decision, if he also has to do little 2 as well. But if all he's got to do is little 1, 3a differs on a matter of fact, all he's got to do is tell them at some stage of that and the reasons for it. It may well be that the practice is to tell them in advance, although he's not invited to require them to comment on his departure, if there's no new evidence or new fact involved.
My understanding on this, and it may be the way this is printed from Westlaw, the way it's been printed, I read this as if after the completion of the examining authority's examination, Secretary of State A differs or B takes into account new information,
then 1 and 2 apply.
Then and for either of those 2 reasons, he's disposed to disagree. So because of the matter of fact or because of the new information.
Well, I understand that, and I do agree that 1 and 2 qualifies A and B, but little 2 only applies if the disagreement comes because of new evidence or a new matter of fact. It must be a reference back to B. It can't be a reference back to disagreement on a matter of fact, notwithstanding there is no new evidence or no new matter of fact.
It's an interesting.
I mean, that's what it seems to say if you just read it. It's a foreign language, I know for me, but even so,
My Lord, that's a point I've never thought about before, and I think I'm fortunate in saying nothing turns on it in this.
No, I agree with that, actually, yes.
But I think, my Lord, that doesn't change the 3b point where there's new evidence or a new
It might be that the reconciliation is that disagreement in 3b(1) encompasses disagree and differs from.
Yes.
Does that solve it?
Possibly.
Yeah.
But where it doesn't help you on the submissions is if at some stage, even after quashing, there is new evidence, they need to be told about that, because the mischief is actually to make sure that if they've got new evidence, they've got to have a chance to know about that and be told about it.
Yes, my Lord, my point on that is that here, because of the way Rule 20 works, of course, all of these submissions were new evidence of one sort or another, whether or not you say it's substantial or not. It's all new evidence, and of course that is known about. It's posted on the website. People are given an opportunity to comment upon it, and as I said, at each stage the Secretary of State says, look, this is all without prejudice to whether I grant or refuse. And obviously grant would be contrary to the recommendation of the examining authority. So those are my submissions on
Thank you.
on 1B. 1C, my lords. Here the issue sort of focuses down very much onto the particular wording in Rule 19.3 is for that reason minded to disagree, and in this case was it because of the IBA report, and your lordship has been taken through those passages in the decision letter in some detail. Decision letter paragraphs 34, I think, to about 129 on need. I just want to dip into one or two of those. Clearly critical to the appellant's arguments are the way in which the decision letter referred to the IBA report in relation to air freight demand and forecasts, and your attention's particularly taken to decision letter paragraph 84. That's, I think, page 423.
Yes, that's the high point of this.
And it is important to note certain things about what is said here, because, as your lordship says, it is the high point. 84 says, during the redetermination process, the applicant commissioned a report from IBA on whether additional cargo capacity is required in the southeast of England, and submitted it in response to the second round of consultation. The IBA report contends that 2021 data links GDP growth with air cargo growth. Note that for a moment because it becomes relevant. The IBA report also states that the 2019 air freight figures show cargo is being handled by airports other than Heathrow, and that the total UK air freight for 2020, including the pandemic, slump and civil aviation 5-year, leads to IBA forecasts that demand between 13,000 and 35,000 extra freighter flights per year by 2030. Now that data, that is not for Manston, that is not for the southeast. Those are UK figures. Those are UK figures, and we can see that if we look at the IBA report for a moment. We'll come back to this paragraph, but if we look at page AB 806. Right at the top of that page, 806, based on the 5-year historical UK air cargo growth rates and tonnage, our scenario analysis shows that the extra movements required by full freighter aircraft by 2030 is likely to be between 13,000 and 35,000. So the first point to note, we perhaps go back to where we were in paragraph 84, but the figures have been given there, not specific to Manston. IBA is just talking about the UK generally. It goes on with no additional capacity at Heathrow and only 16,000 increased movements. The Secretary of State notes that these predictions are based on freight tonnage increases of circa 23% in the 10-year period, which appear consistent with the anticipated overall annual growth rate of between 2.4 and 1.8 between 2022 and 2036 referred to in the independent assessor's report on the subject of future tonnages. So what is being said here is the IBA report on line 4 tells us that there's a correlation, hardly surprising, not controversial as I understand it, between UK GDP growth and the amount of cargo. IBA then forecast for the UK as a whole what the growth in cargo will be on that basis to 2030. And the Secretary of State then says, oh, and I've looked at that, and that's completely consistent with what the independent aviation assessor said. Now, it's in that context that towards the end of this paragraph, and this is what the appellant relies on, it says the applicant submitted similar evidence on increased road freight, and then the final sentence, the Secretary of State is of the view that this data demonstrates a sustained growth in air freight demand in the UK. Yes, it does. That is not controversial. That is simply not controversial. It is hardly surprising that over the years to 2030, there will be an increase in UK air freight. So if that is the high point of the appellant's case on this and how the IBA report apparently influenced the decision, and by reason of this information, that is why the Secretary is minded to disagree. A, this is merely consistent with what his own independent aviation assessor had already said, and B, the fact that UK cargo growth will grow is not controversial between the parties. Now,
When you say, sorry, just so I've got in, had already said or was going on to say?
sorry.
IAA, which came first, IAA or IBA?
Well, IAA draft report,
Yes.
and then
Right, so the draft report was there before the IBA.
yes, because
Okay.
the second round of consultation was, will everyone please now
Yes, okay.
comment
got it.
on the IAA draft report?
Right.
And we did, and on behalf of Mrs. Dawes, York Aviation did, and other people did as well, lots of other people.
Right.
And so, again, my lord, I try to sort of limit what I say because of time and focus on what I understand is the key issue. But if that is the high point, then my respectful submission does nothing.
Well, I think realistically we're going to have to, there clearly must be an opportunity for Mr. Harwood to respond. So
yes, I will move on. My overall submission on this and the way the IBA report was looked at is that it's absolutely clear that the disagreement with the examining authority was not by reason of the IBA report. And in any event, the IBA report, when you look at the various places it's mentioned, are either not picked up in the conclusions on that section or are simply consistent with other material that's been put forward. I draw attention to one thing on this point that I think your lordship were not taken to, and that is in the ministerial briefing. So in the ministerial briefing, we need page 893. And on bundle page 893, paragraph 5, this is where the minister is being told about places where we disagree with the report. And if you go to the second bullet point on the next page, demand forecasting, they refer there to the weight given to the azimuth report, but the IBA report isn't mentioned. No indication there that they thought they were disagreeing with the examining authority because of the IBA report. And that confirms the position that the judge in this case, in my respectful submission, rightly came to, which was that it's the difference in the weight on the azimuth report, not anything that was said by the IBA report, that was important in the disagreement with the inspector's decision, the examining authority's decision.
Yes.
My Lord, then there are a number of points which I'll try and take briefly, but in my skeleton, at paragraph 33, sorry, 53, I apologise, 53.
So this is ground D.
This is ground, this is still C.
C, okay.
My Lord, ground C. I say there, even if Rule 19 applied and was engaged, two further considerations. A, whether there was substantial compliance, and B, whether the appellant suffered any material prejudice. And substantial compliance I deal with in paragraph 54. But substantial compliance, I rely on that. Substantial compliance I deal with in paragraph 55. And paragraph 55 has a number of sub-points which I will draw attention to and just lightly touch on a few of them. So paragraph 55A makes the point which Your Lordship raised, that the IBA report was produced as part of the second respondent's response to the IAA draft report, and the appellant also produced substantial material, including a report from York Aviation. The next point, the IAA took account of all the consultation responses, including IBA and York.
Well, could we deal with it this way, because I'm conscious as you are of the time.
Yes.
We're grateful to you, Mr. Fore, for the very full skeleton argument that we've got here.
Yes.
I mean, if you'd like to identify the paragraphs which in
Yes.
particular you want us to consider, we can read them for ourselves.
My Lord, yes, I draw your attention then to 55C.
Yes?
And there's a typo in the first line where it says both the IAA, it should be IBA. I do
Thank you.
apologise for that. That paragraph is important, and you'll see there are a number of footnotes there, and those footnotes relate to the supplementary bundle.
Thank you.
Because what you don't have before you, you have the IBA report, but you didn't have the York report. And the point I'm making there, and it's an important point in our case, is that the IBA report did not simply sort of pop out of the ether as some new thing. It was a specific response to the IAA's draft report. And both the IBA report and the York Aviation report, as is dealt with in paragraph C here and in the footnotes, deal with exactly the same points. They're both addressing the same points. So it's just not appropriate to say that the appellant here needed the chance to respond to what we had said. We were both responding to what the IAA draft report had said, and presumably York Aviation had said all they thought appropriate on that. My paragraphs then go on. I won't read through any more of those, but I will just make the point that in the third consultation letter, it is made clear that any redetermination correspondence that is put in, if people have put in responses to IBA, that can be made a consultation response and taken into account. So say that it is wrong to characterise the IPA report as something that just sort of suddenly emerged and no one knew about it. It was part of the process, and not just these two parties, but other parties as well were making representations. Move on then to 1D. And this is the point about procedurally fair, and I think for that I can rely on the learned friend's submissions. Appeal ground 1E. Again, I draw attention to my skeleton argument on these points. We say that looked at as a whole, there is no real distinction or difference between the draft decision letter and the final decision letter. They use very similar language, and the briefing material and those decision letters should be read fairly and as a whole. And in his paragraphs 88 to 91, the judge got it right on these particular points. The final point I just make is this, and I apologise for the, I can't say typo, but error in my skeleton, one word right at the end. I refer to simplex, of course it should be section 31(2)(a) of the Senior Courts Act. This case, we say it was highly likely that the outcome would not have been substantially different if that particular error had not been there, so that relief should be refused. And one only has to ask oneself the question, if the Secretary of State thought he couldn't take into account the capacity at other airports, well, if he had taken into account that capacity and had been told, as was the case, that of course that may not come forward, we say would have made a different decision, and that's the important point, rather than focusing on whether it's material or whether it's a matter of weight. The point is, the advice very clearly to me is that look, these other capacity just may not come forward. My Lord, I do apologise for somewhat galloping through.
No, you've compressed it very helpfully. Thank you. Thank you very much indeed, Humphreys. Yes, do you wish to reply?
2 points, my Lord. Could I just have, I think just one of the lectern to my Lords, I will be short, and what I'll endeavour to do is not repeat what we covered this morning.
You're not allowed to do that.
So
you're not allowed.
Certainly not. But what it does mean is that I will sort of simply dip into some points that need responding to.
Yes, well, I mean, I see the time. You have quarter of an hour, 20 minutes at the outside if you need it.
Endeavour to. So, simply, my Lord, first of all, on the azimuth point, that, of course, was being criticised by York Aviation. You've been given the reference at page 567, paragraph 7.8, and that is in the examination process when they were acting for the then site owners. The significance of the evidence base is established by the examining authority's report, where, as we've seen, they say it is leading to the forecast, and that's the examining authority at page 696, paragraph 523. So the forecast by azimuth relied on the evidence base. So if the evidence base is not chosen, that makes matters unfair, then the azimuth report itself should not have been dealt with and taken. I mean, how the offence is cured is not, in a sense,
Did you
probably the
make
question.
that submission to the examining authority? Did you say you can't have regard to this at all because we haven't got the underlying interviews? Was that part of your case?
Well, it's to say that it's unfair to take the ASIF report into account.
But was that your case? You can't have regard to it, examining authority. Don't even give it any weight, even little weight. It's simply not something that procedurally you can have regard to. Was that the case before the examining authority?
Sorry, was that the case put before the examining authority?
Mm.
It was point out the criticism was made that it was simply impossible to understand. And you'll pick up York Aviation's point, which is at page 567, paragraph 7.8. There, and so this is York Aviation during the examination. It's simply not possible to relate proposed services to be operated with the responses by the interviewees. Complete absence of any explanation.
Where are you reading?
Sorry, page 567, paragraph 7.8.
7.8, so I was reading.
Yeah, at the second sentence.
Yeah, I've got that. Sorry.
Yeah. So that's basically looking at saying that we can't understand where this comes from and what's being presented.
Don't wish to interrupt you, but I did forget to ask Mr. Humphreys, what are we going to do with your application in relation to York Aviation? Either if you...
My Lord, I was, for obvious reasons, suggesting that it went in. It relates to that paragraph 55C, so that you can see that actually both IBA and York are commenting on exactly the same things. In other words, insofar as York, and who were representing Mr. Dawes at that point, wanted to comment on those issues, they have commented on those issues.
Could I go backwards down the line? Mr. Westland Smith, do you object to the mission?
No objection.
Right. Mr. Harwood, what do you say about it being admitted first?
Well, my Lord, perfectly content to go, but of course, firstly, in admission, perfectly content for it to go in, and then deal with the consequence of that in a moment or two. So I can pick. So, Lord, I want to turn to IBA and IBA, as we've looked at, is dealt with in the decision letter. We've looked at the references. That is a point of significance, and my learned friend, Mr. Humphreys, drew attention to the ministerial submission, to the minister, which we have at page 894, and to demand forecasts in the second bullet point. And he says, well, that's a reference, that refers to the azimuth report. What it lists there is the decision letter, amongst references to the examining authorities report. It lists the decision letter, paragraphs 81 to 94. And if we turn those up in the draft decision, which we find that starting at page 922. The numbers have changed slightly at this point, but at page 923, paragraph 86 is what's now, I haven't checked whether there's any differences in text, but 86 is dealing with the IBA report, what is now paragraph 84. So when officials are explaining the areas where we disagree with the examining authority, they refer to what's now paragraph 84, which is the lengthiest summary on the IBA report. And of course, this is all part of the Minister's reasoning for his decision. The examining authority's report is 1,000 pages. The decision letter is lengthy, but it's about explaining his reasoning. He's not throwing in text he doesn't consider he needs for the reasons. So those are matters of importance from what is a considerable volume of material. Now, Mr. Humphreys was referring to the IBA report and paragraph 84, suggests, well, this is, in a sense, this is sort of rather general stuff, or it's obviously uncontentious. If we go to simply to the paragraph my learned friend referred to in the IBA report, which is page 806, and at the top of that page, he's talking about F-rated growth, and says that's not contentious. Well, what that paragraph will also do is not simply relating a growth in air freight to a growth in air freighters, so cargo-only flights. IBA is saying this assumes a rise in the mix of cargo carried in full freight aircraft from 30.4% currently to 35% in our mid-case. So the IBA figures for the number of freighter aircraft is not simply saying, well, the amount of freight is going up, so the number of freighter aircraft goes up. They're saying actually that more of the air freight is carried in freighters. And that is, of course, the sort of point that doesn't necessarily follow. And just to pick up one example, I don't want to get into the weeds of the documents, but I want to illustrate why IBA and having the opportunity to comment on IBA becomes important. Because if we look at page 852, which is part of the final version of the assessor's report, there's a table at the bottom, table 1 at the bottom of that page, and going on to the next page, is what's been happening with air freight between 2009 and 2019, which shows that the volume's increased, but actually the volume in belly hold has increased 30%, and the volume in cargo aircraft has increased by 12%. So those sorts of issues is where the increase is, and the applicant's case is not simply it's going to be more air freight, but actually it should be dedicated flights rather than belly hold. Those are the important issues. Now, my learned friend supplementary material seemed to say, well, York Aviation were making points on that for the claimant at the time. Well, York Aviation were making those points without seeing what IBA were saying. Were the boots somewhat on the other foot? Mr. Humphrey's clients may be saying, well, we weren't able to and weren't invited to comment on what York Aviation were saying. What that illustrates is that there were important and contentious issues, but in terms of triggering the duty to consult, sort of brought, again, the whole point's been should have been consultation, was there? In terms of the duty to consult, the IBA report was of importance. It was a reason why the Secretary of State was disposed to disagree with what was said. It was of course, whilst, to take Lord Justice Warby's point, a lot of it was going over similar ground to matters being covered by Azimuth. The Azimuth report had been disagreed with by the examining authority. The Azimuth report was evidence gathered in 2016. IBA was bang up to date on terms of that material. It's material which went into that question of where the figures were. It's supported one side. The Secretary refers to it, the Civil Service submission refers to it by that reference. It is more than sufficient to trigger the need to consult and the operation of 19.3. And that opportunity wasn't given. The Secretary of State didn't invite comment on that. What the reader was meant to understand by redetermination correspondence and how it was going to be dealt with is left unclear. Sometimes you publish at the end doesn't explain how it's taken into account when the Minister is saying you should do look at formal consultation, put it in as things in as a formal consultation response. So there was a failure, breach of the rules, breach of fairness, and that wasn't cured by what in substance happened on that. In terms of the final point on capacity, we've gone through those. I'd simply make this point. The Minister is told something is not material. He's told elsewhere that weight should or shouldn't be given to something. It is told not material. It is a straightforward distinction in law. It's not a silver point. It doesn't need the civil service to advise a minister if he shouldn't be looking at something to say it would be unlawful for you to look at it. To be told it's not material is what he was told. And that was erroneous, as you see with what's changed on the text. My final point I want to deal with, my Lord, on this is Mr. Humphrey's reference to section 31.2a. So it was highly likely it would be the same. And the point is made, as I understand it, simply on the third point on capacity. But the future capacity at other airports was one of the reasons for the examining authority leading to their recommendation to refuse. It's one of the 5 points which the civil service submission tells the Minister we are disagreeing with the examining authority on. Whilst the civil service advice may have been we'd be sort of suggesting there's uncertainty about it. If you're going to suggest, well, maybe little weight to it, but the examining authority didn't give little weight to it. The minister was entitled to consider it. He was certainly entitled to agree with the examining authority that it's a point of importance. So the section 31.2a point, respect to my own friend fails, if the Secretary of State's position was wrong, the decision was wrong on the capacity point, then the outcome would be to quash. This is obviously a lengthy process that's been undertaken, but these are important points. The Minister's disagreed with his expert advisors, and he's disagreed in this case with his expert advisors in a manner which is unlawful. And so, unless I can help the court any further, for those reasons, my lords, the appeal should be allowed and the grant of the development consent.
Thank you, Mr. Horde. Thank you to all the advocates for compressing the argument into the time that we have allowed. We'll clearly consider the matter carefully and let you have our decision as soon as we reasonably can. The lawyers here will know the process. We will let you have our draft judgments, which are to be seen only by those who are on the list held by our clerks. In this particular case, it would be a case in which if there was any default in relation to that, it would be treated seriously. Until the judgments are handed down, there must be no disclosure of the draft judgments to anybody who is not on the list. We'll then be grateful for editorial corrections and a draft order reflecting our decision, and we won't need to trouble you to return because the judgments will be handed down electronically in the normal way in due course. Thank you all very much indeed.